Good afternoon. I'm Leanne Jackson, Senior Law Editor at Forbes, and I am joined today by Neama Rahmani. He is the president of West Coast Trial Lawyers and also a former federal prosecutor. And I wanted to talk to you. I'm glad that you're with us because as a former federal prosecutor, I wanted to find out a little bit more because today we're talking about Judge Aileen Cannon and her latest decision to dismiss the classified documents case against former President Trump, to dismiss the entire case. And one of her reasons in the decision was that she felt that Special Prosecutor Jack Smith was unlawfully appointed. I want to get your take on that and what this means for going forward and for potential appeal.
Leanne, I was shocked. We have decades of precedent appointing special prosecutors in this country, and Judge Cannon ruled that that appointment was unconstitutional for two reasons. First, senior officers of the United States, like the Attorney General and U.S. attorneys, have to be appointed by the president and confirmed by the Senate. So Judge Cannon ruled that Smith's appointment violated the Appointments Clause of the Constitution. She also said that because the special counsel is funded automatically, that violates the Appropriations Clause of the Constitution, which requires Congress to affirmatively decide whether to appropriate funds or not.
Do you think this was quite an interesting decision? Some people have called this sort of a stretch, and that a lot of her decisions have seemed to be trending towards finding ways to at least, at the minimum, delay the case. And in this case, she's tossed out the entire case. What do you think about the reasoning behind those that you described just now?
Judge Cannon is either a bad judge or she's biased. She's considering arguments that no other judge would, and she's favored Trump at every possible turn. I felt that she may dismiss the case, but on presidential immunity. The Supreme Court gave her a very clear path to do so. But to rule that the special counsel is unconstitutionally appointed, that's something that has ramifications, not just for this case, even though she said a ruling is just limited to this case. Think about Hunter Biden, who has been and continues to be prosecuted by a special counsel. The same reasoning would apply to his case. Should his case be dismissed, no other judge would have considered this argument. No other judge would have granted this argument. I wouldn't be surprised if Judge Cannon gets reversed on appeal by the 11th Circuit or even the Supreme Court.
The 11th Circuit has not been a fan of her previous rulings. Do you feel like this also opens up an opportunity, as some have said, for the special counsel to ask for a substitution of the judge in this case to replace her?
I wouldn't be surprised. Cannon's already been reversed twice by the 11th Circuit, which does lean conservative. I would expect them to reverse her again, either a three-judge panel or for a petition for a rehearing en banc, which would be the entire 11th Circuit. There's really no precedent for what she's done. And even in the unlikely scenario where the 11th Circuit affirms her ruling, now we have a circuit split and the Supreme Court would have to step in, hear the case, because there are constitutional consequences for what she said. And ultimately, you can't have some circuits saying that the appointment of special counsel are unconstitutional, others that allow prosecutions to move forward.
You know, in this case, Trump was indicted on 40 federal felony charges for allegedly withholding national security documents, keeping them at his home in Mar-a-Lago, bringing them back to his private residence, and obstructing the investigation after that. If Judge Cannon's ruling were to be affirmed, which most observers feel that's not going to be the case, but if that were to happen, stranger things have been happening in the courts these days. What does this say for the future of presidential immunity? We've seen a lot of cases that are testing the limits of executive power and potentially abuse of power, that you're able to just take classified documents, allegedly in this case, and do sort of whatever you want without consequences.
Well, it's a huge issue, and they're two real separate issues, right? Presidential immunity. The Supreme Court gave a very broad definition of what constitutes an official act, in which would be subject to immunity, versus a personal one, which would allow for a criminal prosecution. But I think this is just an entirely separate issue altogether. We're talking about the appointment of a special counsel, which should be appointed in a case where the president or the attorney general may have a conflict of interest. Let's not forget, this is the Justice Department that's prosecuting Donald Trump, or the Justice Department that's prosecuting Hunter Biden. So if we're not going to allow for special counsel appointment in these types of cases, we're going to rely on local U.S. attorneys who are appointed by the president, confirmed by the Senate, and they may be aligned with the president, which may create a problem.
And also, this ruling does come after Clarence Thomas made a Supreme Court Justice Clarence Thomas made sort of an allusion to the fact that
Yeah, sure.
that the special counsel may be inappropriately appointed. Do you feel like Judge Cannon took a cue from that, and the timing of this in general?
I agree that Judge Cannon took a cue from Justice Thomas. This is a fringe argument. Not many folks would entertain it, but Justice Thomas, in one of his opinions, did say that the appointment of special counsel may be unconstitutional. I think Judge Cannon took that argument, ran with it. Certainly the defense did in their briefing and their arguments. And I think that's something that ultimately, if you poll legal scholars, if you poll judges, I don't think many would agree with this ruling. I'm currently teaching, I'm currently helping run a program at my alma mater, Harvard Law School, and talking to professors here when the decision came out this morning, they were shocked. This is not a majority opinion. Whether you're talking about Judge Cannon or Justice Thomas, there's not going to be a lot of judges that agree with it.
So much of what's come down lately has been what most would describe as unprecedented. In general, Neama, what are your thoughts on the former president has had a number of legal not wins, but successes in terms of delaying trials. I mean, he was convicted in New York on 34 counts, but so far on many of these other cases that people thought were going to be sort of not slam dunks, but definitely solid cases against him, some of the most important cases against him, he's had, it's been very fortuitous for him. What are your thoughts on how this has played out?
No question that Trump has had a lot of procedural wins. And if you look at the cases, the Hushmany case was probably the most questionable in terms of the charges and the merits. And the classified documents case, many legal scholars thought it was a slam dunk. The documents were removed from D.C. They were at his personal residence in Mar-a-Lago. That, if you believe the allegations, Trump refused to reply to a lawfully issued grand jury subpoena, tried to obstruct justice, hide the documents. So if you look at the different cases of the 4 criminal trials, a lot of legal scholars thought that this was the strongest case. But of course, Judge Cannon was such a favorable draw for Donald Trump. And at every stage of the proceedings, whether it was discovery or disclosures pursuant to the Classified Information Procedures Act, she's delayed this case. And we know that delay is the friend of the former president. If some people would say when he's reelected in November, it's well established that a sitting president can't be prosecuted. So all these cases, whether it's South Florida, whether it's Washington, D.C., or even Fulton County, would have to be dismissed.
Because there's no timeline and when the 11th Circuit would even take a look at this point, correct?
Oh, of course, Jack Smith has 30 days to appeal, but by the time there's a briefing schedule and oral arguments, there is no way we're going to get a trial in the documents case before the election. Judge Cannon, even before this ruling, taken the trial date off calendar indefinitely.
Right. So she made sure of that. Even before this happened. And so just real quick, I know you have to go. I appreciate you joining us. You're kind of talking to us from a classroom there at Harvard, and I appreciate your time. But I wanted to get your opinion, because I know you've discussed this as well, on the Alec Baldwin case. Another surprising ruling out of Arizona, where the judge tossed that case because prosecutors hadn't turned over bullet evidence that the defense had requested or didn't know about. One thing I do want to ask you about this is, you know, he's a celebrity. He has high-powered attorneys. Do you feel like that played into the decision to dismiss this case with prejudice against Alec Baldwin?
I think the Baldwin case was more of a loss for the prosecution than it was a win for Baldwin and the defense. And obviously Baldwin's lawyers at Quinn and Emanuel, they did a very good job. They went to Harvard Law School, where I'm at right now. But every first-year law student knows that you have to disclose exculpatory evidence. It's a criminal law issue, it's a constitutional issue under the U.S. Supreme Court's seminal decision in the United States versus Brady. So the fact that the prosecutors in the case, Morrissey and Johnson, received ammunition that suggested that someone other than armorer Hannah Gutierrez Reed supplied the live rounds that showed up on set and killed cinematographer Helena Hutchins, that was evidence that had to be disclosed to the defense. Because the argument is Seth Kenney, who has a prop store, he was the one who was responsible. And the fact that the prosecution didn't disclose this evidence was such a huge intentional error. That's the important part. When Morrissey took the stand, if she had testified truthfully that it was an inadvertent failure, maybe, just maybe, the case could have been salvaged. But it was clear that the failure to disclose this exculpatory evidence was intentional. The judge had no real choice but to issue the ultimate sanction, and that was dismissal of the case.
I thought the prosecutor had also suggested that it was an inadvertent mistake, an oversight, that they had not turned over this ballistics evidence. Is that incorrect?
I think that was because there was an affirmative decision to place it in another file that was not disclosed to the defense. And I think it was that decision that the judge in the case pointed to. And let's not forget, this isn't the first mistake made in the case. It was certainly the most serious. But from the beginning, the prosecution charged an unconstitutional enhancement. The New Mexico legislature passed a law that called for a 5-year mandatory minimum sentence in state prison for certain types of firearms enhancements. And obviously, we know that criminal laws can apply retroactively. That law was passed after the Rush shooting. Prosecutors tried to charge it, but that was stricken because it violated the ex post facto clause of the Constitution. Then the district attorney appointed a member of the New Mexico state legislature to be a special prosecutor in the case. And we know that's a separation of powers issue. Prosecutors are part of the executive branch. And obviously, legislature is the legislative branch. And when it was clear that prosecutors weren't ready for a preliminary hearing, they didn't dismiss the case, go to a grand jury and get an indictment a year later. So really, this is the fourth mistake in the case, probably one of the most botched prosecutions in American history. And really, people should lose their jobs and potentially get sanctioned by the state bar. I mean, these are some really bad violations by the attorneys handling this case.
Yeah, it was almost a soap opera in itself. It could have been a movie, like the stumbles that kept appearing and kept happening in this case. Like you said, there were a lot of botched and missed opportunities, not making a judgment on whether Alec Baldwin was guilty, but the prosecution definitely missed a lot of opportunities. I really appreciate you speaking with us, Neama, on both of these cases and giving us your time. And I hope you'll join us again. It was a fascinating discussion of these really intricate and interesting legal cases that are taking place. And I appreciate your time.
Thanks for having me, Leanne. Look forward to being on soon.